that there are drugs there. The police then, on her consent, search the house, acting in the best interest of her children. So we have a case where
children or child?
Huh?
How many
children? I'm sorry, child. So you have a case where he says versus she says. So essentially we have a tie.
Then why have an action at all?
Huh? Hold on, I'm getting to that. We have a tie.
Just read the dramatic pause. I'm sorry.
In this case, we have a tie. So now we must have a tiebreaker. In this specific case, I believe that it is very important to err on the side of safety when a child is involved.
Is it because she's the mother?
Huh?
Is it because she's the mother?
And he's the father.
Is it because of that reason?
That she would have...
We see all the time in custody hearings that mothers more often receive custody of their children because it is not written anywhere, but it is assumed that mothers have more nurturing instincts. If these were switched, would it make any difference?
No. As long as the best interest of the child is involved, I think you have to err on the side of public safety and safety of that child. So therefore, in this case, this tie needs to be broken in the way that it is best.
How do we know that the father had been acting in
fear of what the mom
fear of what the mom would
like
do?
he took the child because the mom was threatening the child.
Right.
And how do we know that the mom's drugs weren't what was in the bedroom?
That's kind of beyond the scope of this case. We're taking a look at was the search constitutional. Mr. Randolph, I don't know what the district attorney did when examining all the evidence. The district attorney took a look at all the evidence, decided to prosecute Mr. Randolph based upon what was done. Mr. Randolph went to trial. He was found guilty of drug possession by a jury. Now he is asking to have the evidence that convicted him thrown out.
Something you said, Triton, you said that we should err on the side of safety. I mean, I think that's a statement right there that this might be an error. We should err on the side of safety. So could this search all be illegitimate because it is an error?
Not an error, E-R-R. But nonetheless, it is a situation where we have to have some guiding principle. I don't know if there is a right answer to this, but we do have to act in the best interest of this country and our children. And in that case, our children as a whole.
I don't have children.
So that if, I don't either. So if we have a situation where, this is very, very similar to maybe a school case, where once a child enters the school building, certain expectations of privacy for the best interest of children take precedent here. So now we have a situation here, if this was at a school, there would be no question. The school would have every right to search.
Now, since we're making such a case about this being to protect our children, can you describe the living situation of the child? Where was the child? How did the child go back and forth between the parents? I read somewhere that they were taken to Canada. Is that true?
Yes.
Okay, so can you just explain that? From the mother leaving, what happened to the child?
The child went with the mother. They came back. The father was visiting, took the child, felt that the mother was endangering the child. But again, this would be a case that I think a divorce court would be best suited to be able to determine the custody of the child. We're dealing with the constitutional issue of certain seizure.
You brought this up. You brought the child in.
No, I understand that. But the history of the child, here we have a case. It doesn't matter if it was her drugs or his drugs. What matters is that there were drugs in a place where the child would, at times, reside. And I think we have a parental expectation that the parents should be able to keep their children from such.
California law states that in order for a mother to cross state borders, I know there's other states that do too, that they have to have permission from the father. Is that the case in Georgia as well?
In a divorce situation, we do not have a divorce yet here.
I have something I'd like to point out. On page 8 of your brief, in the second paragraph, it says, based upon the objective standards of reasonableness, this court deems valid a search unducted. What's unducted?
I'm sorry, I forgot to see.
I just had to point that out.
Thank you.
I looked on the rubric that you were being paid, but there is a spelling and grammar area.
Forgive me a 98, I'm sorry. Yeah, that's supposed to be conducted. I'm sorry, that was one of those.
Thank you for that.
After I sent it out to you.
I just wanted to clarify that.
Thank you.
I have a question.
Yes.
So basically what we're saying is if there's children in the household, there's a lesser expectation of proper police procedure?
I don't think it's a less expectation. Here we have accusations. Again, children in the household, I'm not by any means saying that the police, there's children in the household, let's search the house. I'm not by any means saying this. I'm saying we have an accusation, clear accusations, and the court has historically said that hearsay evidence, which an accusation is, does not deny the police the right to search. That if they have a reasonable cause, and her consent to the search gives it that. And because the children or a child is present here, now the accusation needs to carry an acceptable Fourth Amendment search. And again, it's with the accusation. If there's no accusation, then yeah, the police have no right to go into the house. But there's an accusation and a consent here.
You said you wanted to save 5 minutes. Were you wanting me to stop you when you had 5 minutes left, or are you going to?
No, I mean, I'll keep, when the goes wide, I mean, I'll definitely.
Are you saying that because of the accusation that gave them more reason to go into it?
It gave them a reason to ask for the consent for the search.
Okay.
And the court in United States v. Matlock, there's no automatic rule against receiving hearsay evidence. So they got the accusation. They then followed proper police procedures, asked, you claim this is in your house, do you mind if we search? She consented to that. And he said no.
Well, actually, he said no.
He said no, but it was on her
yes.
accusation. And again, we have a situation here where, you know, the tie needs to be broken to the side of.
What exact reason are you saying we should break the tie in your favor? What is the single reason? I mean, to sum it up into one reason why it's. Is it the children? Is it protecting our children? Is it?
Yeah, I think it's. I think that we have a societal obligation to raise our children in drug-free, environments. I mean, that's why we have. That's why Congress passed a law to Safe Schools, Drug-Free Act.
Wasn't the child across international borders? Wasn't the child in Canada? Well,
for a time.
The mother brought the child back to the home.
Yes, as she was coming back to pick up her belongings, the father spent time with the kid, the child, and then...
To pick up her belongings?
To pick up her belongings.
Not to live there?
Not to live there, to pick up her belongings.
So
but since her belongings are in the house, it is still part of her residence.
If she's picking up her belongings, is she a co-inhabitant of the house?
As long as she is married, I'm going to say yes, because it is...
Now, co-inhabitant of the house. Is she inhabiting the house?
If her belongings weren't there, I think we have to say that not necessarily a cohabitant, but a marriage does. I mean, when you enter into a marriage, you mean you have a case where you don't have to.
To what extent do you think a marriage makes it look as if she would be living in the house?
I think a marriage has a reasonable expectancy that what is owned or what is theirs is shared. So she has every right to consent. United States v. Matlock says that she has every right to consent to a search because she is married. I would like to save my final 2 minutes for rebuttal. All right.
Thank you.
Okay. Thank you, Mr. Chief, and may it please the court. We are here to establish that our Mr. Randolph's Fourth Amendment rights were violated by his wife, Mrs. Randolph, and the subsequent intrusion of police into his home, and asked that the evidence found in their residence be thrown out under the exclusionary doctrine. Mrs. Randolph consented to allow the police to search her husband's home. She was just picking up the last of her personal items, for her and Mr. Randolph were in the process of a separation. We believe the case comes down to 6 basic principles, which are as follows. This court has approved search on the basis of third-party consent only when the individual has voluntarily relinquished his right to exclude the police. Mrs. Randolph did not give his consent. He explicitly said no. The state's rule would approve the extraordinary intrusion into the core privacy in the home that is the principal concern of the Fourth Amendment. The state's proposed rule would deprive individuals of an ability to protect their privacy in their homes, and as a result would create an extraordinary and pervasive sense of personal insecurity.